Since the mode of appointment of a Supreme Court judges is the most contentious issue in the area of constitutional law today, it would be appropriate for me to reproduce the actual text of Article 124 Clause 2. And it reads as, every judge of the Supreme Court shall be appointed by the President by warrant under his hand and seal after consultation with such of the judges of the Supreme Court and of the High Court in the states as the President may deem necessary for the purpose, and shall hold office until he attains the age of 65 years. There is a proviso attached to this provision which states that provided that in case of appointment of a judge other than the Chief Justice of India shall always be consulted. Now coming to the qualification which has been done under Article 124 Clause 3, and it reads as that in order to be eligible to be considered for the appointment of the Judge of the Supreme Court, one should be a citizen of India and should fulfill any one of the following qualification. So first, one should have been a High Court judge for at least 5 years of one or of two or more such courts in succession. Second, one should have been an advocate of a High Court for at least 10 years or of two or more such courts in succession. In computing this period of 10 years, that period would also be counted in which one held a judicial office not inferior to that of a district judge. Third, one should be, in the opinion of the President of India, a distinguished jurist. So, if you see that if any of the person who fulfills any of the three criteria can be appointed, is qualified to become a judge of the Supreme Court. Now, this is not so as easy because as I mentioned earlier, that this has been the most contentious issue, and that is why we have to see this issue into two phases. First is the pre-1970 phase here, and then the post-1970 phase. In pre-1970 phase, the executive suggestion, and especially if you see a book written by George H. Godbis Jr., Judges of the Supreme Court of India, he did mention that between the period of 1950 to 1989, it was the preference of the Chief Justice of India which was generally taken when the appointment was to be made. So, if you see the 1970 phase itself and the post-1970 phase, if you see a difference which I am going to talk about in my next video. Thank you.